Welcome. I'm Justin Paperny with Prison Professors. Thank you so much for taking time out of your busy day to join us and to learn more about how trial proceedings begin. If you're watching this on YouTube, please like, subscribe, and comment. And of course, if you're rolling around listening to this in your car via our podcast, thank you. We want to educate and inform you on this very warped world that is the criminal justice system. And to that end, COVID, as many as you likely know, delayed the proceedings of guilty pleas, of sentencings, of trials for quite some time. And it's very easy to get lured into the delays and thinking, my goodness, they may have forgotten about me. In fact, a client of ours at White Collar Advice and Prison Professors just pled guilty, and he received his target letter 2.5 years ago. And over this process over the last 2.5 years, he was never formally arrested. There were no conditions because he just signed. He's just now signing the plea agreement. And it was very easy during this window to think, wow, they have forgotten about me. If I was that big of a criminal, would they really be letting me out doing my thing and with no restrictions? I have my passport. I've been to Europe. I've been to Asia. And the answer is yes. Much of the time, the government knows you're not a continuing threat to break the law, that you're not going to go out there and steal and cheat. In those cases, they will absolutely ask the judge to remand you to custody, or the bail amount may be set so high you have no chance to meet it. So it is not uncommon for cases to play out for quite some time, including hundreds of millions, even billion-dollar potential frauds to remain free. But eventually the government is going to seek to serve justice. To that end, as we go to our trusty screen share, our team at Prison Professors, and by way of some media outlets, are covering this very popular trial in Silicon Valley. And while popular, it is a bit of an anomaly for someone to go to trial, as articulated in a recent video and podcast, the trial tax or trial penalty. More than I think it's 97% of people plead guilty because the odds of prevailing at trial are so low. In fact, I think 1% of people prevail at trial. I wish you a lot of luck if you go. So our team has said, or at least I have said, if you go to trial, you're either insane, or two, you're innocent. Or I guess a third reason, you may feel as if you may have done some things that civilly could be an issue or gray, but you don't believe it to be criminal. You might not have had intent to defraud or harm. Of course, the government sees these things differently. So I know you're not insane. And if you're contemplating going to trial, it must be because you're innocent. And if you are going down that route, our team helps you win, because we hope you win, because we believe we send too many people to prison in this country for periods of time that are far too long. Coming back, as I mentioned, to COVID, this Theranos case with Elizabeth Holmes was delayed in part because of COVID. A jury selection finally began recently. We're covering this in a number of blogs. And this trial has to do with this Theranos company that was once valued at $9 billion. And it's a blood testing company or startup that Holmes formed or launched way back in 2003. Our team feels this is a good opportunity for people to learn more about the criminal justice system, the ways that it works, the strategies to get through it successfully, understanding the perspective of stakeholders, a prosecutor, a probation officer, a judge. What can a defendant do to mitigate, even if convicted at trial? Indeed, at White Collar Advice and Prison Professors, a number of our clients, unfortunately, have been convicted at trial, though they still get below the guideline sentences, are much lower than the government would like because of their mitigation, because of the work they're doing to create a record that shows they're different from the government's version. So the key thing is, whether you're going to trial or not, mitigation, it's a 24-hour-a-day job. You just don't wait until you've been convicted or pled guilty. Over the weekend, I received a message from a defendant in a case who said, my lawyer told me not to do anything. My lawyer told me that I'm doing everything perfect. And it's so absurd or insane for a defendant to hear that you're doing everything perfect when he's not working for years, when he's not doing any community service. He's not really doing anything to make amends. He's not doing anything to demonstrate that he's different from the plea agreement that he signed. It's just foolish and dumb. And it comes down to you exercising your own judgment. So as you go through this process, whether you think our team has the best advice or somewhere else, dissect it, ask tough questions, seek follow-up and data, and do your due diligence. But because me or a lawyer says you're doing it perfect, you've got to exercise and use your own due diligence. I cannot stress that enough. And the more lead time you have building up to it, the more authentic you look. For example, let's just say Elizabeth Holmes is convicted, and just like that, she begins doing community service work. Well, it's not really that impressive for the judge. What would be more impressive is if it were going on for an extended period of time. That's why the best day to start is today, or the analogy of when's the best day to plant an oak tree 20 years ago, the second best day is today. You've got to start. Now, to the background of this case, Theranos was started by, I hope I'm saying Theranos correctly, was started by Holmes at the age of 19 while dropping out of Stanford. She's been compared to Steve Jobs, primarily, I think, because of this turtleneck she liked to wear. And in so doing, she also hired her romantic partner, Sunny Balwani, to work with her in 2009. As you will see in the press, an interesting legal strategy her team is using, is that she was coerced or manipulated or taken advantage of by Sunny Balwani. I'm not quite sure how that's going to work out because it may not excuse her role in breaking the law or in defrauding investors for hundreds of millions of dollars. It could be a part of the story. It's certainly a mitigation technique. It's a strategy, but I'm not sure it's the best strategy to potentially say, yes, I did it. However, I was coerced. Then again, when you're going to trial, it's all hands on deck. This company, Theranos, as will be articulated through trial and in our blog, and you can read the full blog at prisonprofessors.com. This company raised more than $700 million, and they were striking high-profile deals, primarily with Walgreens and Safeway, to offer blood testing in all of the stores. There was a conference in 2014, and I quote, "We've reinvented the traditional laboratory infrastructure. Our technology eliminates the need for people to have needles stuck in their arm," which would be great for a lot of people that I know, including my daughter, who's not a big fan of needles. Today, Walgreens acknowledges that it did not first validate Theranos' blood testing technology before entering into the deal. So perhaps Walgreens, too eager, too anxious to secure this primary deal, and in so doing, didn't fully do their due diligence to the detriment of their brand, their reputation, their shareholders, and now they're embroiled, unfortunately, in a large criminal investigation, in fact, a trial. By 2015, with the help of whistleblowers, I discussed the importance of whistleblowers in a previous video, including the compensation that whistleblowers can work their way into for the risks that they take in whistleblowing, the way that whistleblowers help ferret out wrongdoing. In this case, a whistleblower published a series of articles exposing the company's practices, essentially saying this device claimed to fix this issue didn't really exist, and company that passed off blood test results conducted on regular commercially available machines as if they came from their innovative technology. That's a no-no, especially when you're raising hundreds of millions of dollars in the interim. The criminal charges, as the government's going to lay out in this case, states, as we've heard again and again and again, that Elizabeth Holmes and her co-defendant, Sunny Balwani, who will be tried separately, knowingly misled investors, doctors, and patients about their blood testing technology, like we hear in Ponzi schemes and mortgage fraud schemes and whatnot. They are calling this a massive fraud scheme where they lied to doctors, patients, and investors about the company's ability to perform these tests for illnesses using just a drop of blood. They're going to show, the government intends to show, or they're going to try to, that all of it was real. According to the indictment, the government charged each defendant with 2 counts of conspiracy to commit wire fraud in connection with, I'm not even going to get into the statutes, but I can assure you, if you've ever been in trouble, you know someone breaking the law, they did not consider the statute before they broke the law. People don't know the statutes for securities fraud, wire fraud, bribery, corruption. Yet in retrospect, they'll realize how easy it is to get swept into a conspiracy or money laundering or wire fraud just in the course of day-to-day business. That's how many government investigations begin. People think they're doing the right thing, or maybe it's a little grace, some whistleblower, someone gets fired, they run to the feds. Before you know it, there's a full-blown investigation that can take years to come together. Now, the government is spending tons of resources, you would imagine, in this trial, which is part of the reason, if convicted, the government will ask for a much lengthier prison term because of the resources that were put to trial. It makes sense that if you plead guilty immediately, accept responsibility, demonstrate your remorse, you're going to get a better outcome because you're not going to get that trial tax, but also the government may say, the defendant didn't put our government resources to the test. So when you're going to push and make the government prove its case, you're going to get a significantly longer prison term, or at least the government's going to try to ask for it. In this case, the government will try to prove that they made false statements, that their product could provide accurate, fast, and reliable, cheap blood tests, and then they omitted information concerning the limits of this technology. As aforementioned, there are going to be separate trials for Holmes and Balwani. Our team at Prison Professors will cover both, and you're going to see the jockeying, that to the extent that Holmes passes the buck to Balwani, to the extent that Balwani passes it to Holmes, and in so doing, they'll probably get away from the defense isn't going to want to cover the real objective, which is hundreds of millions of dollars were lost. This product didn't do what it said it was going to do, and that's the government is going to be singularly focused on that. Everything else, in their opinion, while a mitigating factor potentially at sentencing, is a distraction. Talking about plea negotiations, I don't know if in this case, if a plea agreement was offered, it doesn't surprise me that it was turned away. Some people will go all the way through trial, even though they know the likelihood of prevailing is low. I served time, our team served time with those people in prison who were adamant that they would win, or just could not accept any responsibility, or wanted to wear it as a badge of honor that they had the chutzpah, the courage to actually go to trial. Some would call it courageous, others would call it insanity. You got to decide what's best for you, and knowing the odds. And I can assure you that Balwani and Holmes knew the odds of prevailing, which is about 1%. We have been asked before if a plea negotiation can begin after trial. We covered that in a separate video along with a podcast where we shared a story of a client who during a trial actually pled guilty, accepted a very favorable plea offer, because during the trial, it turned out one of the government star witnesses turned out he was just caught lying, flat out lying and making misrepresentations. And while the government felt they could still win at trial, it severely weakened their case. So even after trial, our client was able to secure a very favorable plea agreement that kept him out of prison. It was going back several years, might have been home confinement, 6 months prison or something like that. But it actually can happen. Unlikely, but it can absolutely happen. There's also a chance, as we cover here, that Holmes or someone could engage in cooperation against the other, but that would require them to accept responsibility, which at this point doesn't look like that's going to happen. If Holmes were to plead guilty, she would have done it, I think, and she'd have been cooperating against Balwani. I think instead she's maintaining her innocence. To conclude, this case is finally underway, delayed for so long because of COVID. Our team at Prison Professors is going to cover the whole process from jury to verdict on our blog. Media, I've contributed recently to CNN and Business Insider covering this case, what it would be like for Elizabeth Holmes as a new mom, if she were potentially in prison, what that would look like, and that dynamic, including some changes in the law from the First Step Act that may make it easier for her to see her family or baby, including there's a policy if you're sentenced to 30 months or less that could enable her to spend more time with her baby. That's why mitigation, and God forbid if she's convicted, getting the shortest sentence possible is key. To close, whether you're watching this video or listening on a podcast, if you are going to go to trial, understand the risks and rewards, understand the unlikelihood of prevailing, understand the cost that a company going to trial potentially losing. And the cost could include a longer prison term, the expense, getting remanded, a higher security prison, higher fine, more charges. Because as you know, if you don't agree to that plea agreement, they love to do what's called superseding indictments, and then they may go indict the family and kids. It's a ruthless, wicked system. The more you know, the better. And it's why our team is here. So grateful that you're watching this video or listening to the podcast. Go ahead and subscribe, and we look forward to returning soon with more valuable content that will help prepare you and your family, and in some cases lawyers, for this difficult journey through the criminal justice system. Thank you for your time. Goodbye.